Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address some of the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk on a wide variety of topics. Already we've discussed financial crises, how to avoid them, what to do with them when you're facing them, mediation, and most recently we were talking about social hosting laws. Now, at the end of every program, we invite people, our viewers, to email at abcglawfirm.com any questions that have been pertaining to the most recent show that we've aired. And this week we had not an email, but specifically a call, and what we're going to do is cover the question first about social hosting laws. With us today we have from the law firm two new guests, those who are specialists in today's topic. To my far right, Bob Audette, and to my immediate right, Lenny Cordeiro. The question that we're going to be posing first was called in from a gentleman who said that he was in a car accident and he was hit in Massachusetts, but the person causing that occurrence was an adult and he was a Rhode Islander. The question is, can he sue the homeowner? Lenny, Bob?
Well, generally speaking, when an accident occurs, you look to the place or the state where the accident occurs to determine which law will apply. Since the accident occurred in Massachusetts, you'd be looking at applying Mass law. So in this particular case, the social host liability statute in Rhode Island would not apply. However, that person would have rights under the negligence system in Massachusetts to recover for damages that was caused by the person driving that vehicle.
Anything to add, Bob?
No, I mean, it would be interesting to know where the person was served, because then if the person was served in Rhode Island by the social host, then perhaps Rhode Island law could get involved on that end of things, even though the accident was in Massachusetts.
Okay, fair enough. So for today's topic, as we think about the grim economic news such as it is, people are being laid off, people have many hassles daily to contend with. Imagine if you happen to lose your job, imagine if you were having some injury. So today we thought it would be a worthwhile topic to discuss, a very involved topic. Hopefully we'll get through most of it today. Workers' compensation. And from the firm Audette, Bazaar, Cordeiro, and Grasso, we have two specialists with us, as I mentioned earlier, Bob Audette and Lenny. A little bit of background about them. Lenny Cordeiro, to my right, is a graduate of Suffolk University Law School, and he specializes in workers' comp, also personal injury, social security disability, and estate planning. He is also trilingual, which is a very important thing for us to know in this community. And to my far right, Bob Audette also focuses on the area of workers' compensation, personal injury, and social security disability law. He handles many Rhode Islanders and also the federal longshore workers' compensation claim. He's also familiar with estate planning, and these are topics that we're going to be considering in the next couple of weeks. Bob graduated from PC, but has his law degree from Boston University. So as we're getting ready to approach the topic of workers' compensation, I know many people have had injuries on the job or have had some sort of disease perhaps as a result of the job, and they think, oh my goodness, people are getting ready to be fired, plants are likely to be closing, I shouldn't, or should I consider reporting a claim, and what's going to happen if I do? How do you address that? What's the big picture about workers' compensation in Rhode Island and Mass?
Well, I'll touch on Rhode Island. Lenny's more of an expert in Mass than I am. We get that question all the time. I had a young person call me today who just had a burn on the job, and his first question to me, well, second question after asking me about whether he had a claim or not, was, am I going to get in trouble with my employer if I report the claim? And my answer to him is, almost certainly not. Employers obviously are generally not happy when someone reports an injury on the job, but we have always felt that you open yourself up to far more trouble if you don't give notice of the injury immediately. Hold off, because some of these injuries don't go away. We've had many people, countless people come in to see us who've been injured and thought, well, I'm going to tough it out, I'm going to keep working. And then 2 months later, they realize that the injury is too much for them. They might need surgery or whatever. Now they go to the employer 2 months after the fact. Now you've created a very suspicious situation in the employer's eyes. You've made it harder for doctors now to link your condition to the work. And you're really fighting an uphill battle. So our advice to people is 100% of the time, report the incident. If it turns out not to be serious and you don't have a claim or don't need to lose time, you've lost nothing. There are also provisions in the Rhode Island law, we can get into more detail in a little bit, hopefully, about that will help protect your job if, in fact, you do go out on workers' compensation. But I'll let Len talk about the Mass side of things.
Well, Massachusetts, I mean, and Rhode Island are similar systems in the sense that they're both designed to be no-fault systems. I think many people sometimes approach me and say, well, you know, something happened to me and it was my fault, I wasn't paying attention. The beauty of these systems, and it's not just in Rhode Island and Massachusetts, but nationwide, is that it's no fault. So long as you didn't intentionally hurt yourself or you weren't taking alcohol or under the influence of some type of drug, it really doesn't matter. The workers' compensation system has to compensate you for injuries that occurred during the workplace. As far as the differences in Mass versus Rhode Island, Massachusetts does have also protections in place for employees who suffer injuries. It is imperative that you report an injury in a timely fashion because, as Bob suggested, in the Rhode Island system, and much the same in Massachusetts, it does create or raise suspicion if an injury is not reported right away. And, you know, ironically, the person who's been a long-time employee with a company, someone who does not want to make a claim, so to speak, usually those are the people that end up having the hardest times with trying to pursue their claims because the defense lawyers for the insurance companies and for the employers will typically raise the fact that they didn't get treatment right away, they didn't report it right away, and it becomes a suspicious claim even though the person may have been a long-time employee with no previous record of any injuries.
I think you can understand, though, that today especially, whether someone is threatening to fire them or you're on thin ice anyway, you can understand why an employee might likely say, maybe I'll just hold on to it. It wasn't that bad. And maybe it wasn't.
Yeah,
so is it still better to say what's happened?
Yes, I mean, it's easy for us to say that sitting here, but we see hundreds of people a year, literally hundreds of people a year who are injured on the job in Rhode Island and Mass. And our advice is always the same. The odds of you getting in trouble for reporting an injury are much less than the hurdles you're going to create for a potential future claim by not reporting the injury in a timely fashion. It just pays to be honest, and most employers, if the employer is a good employer and they're a legitimate and honest employer and they appreciate your work, they're not going to penalize you for reporting an injury. If they are going to get rid of you for something like that, then maybe they're not a place you want to work anyway, is what I tell people. And again, that's easier said than done when the economy is booming, but it is still a reality.
And just to add to that, there are rights that are also available to injured employees. For instance, if an employee does not report an injury right away and it turns out that they, for some reason, have to lose their job either because of a layoff or some type of retaliatory measure. If it's a retaliatory measure, there is a discrimination law in place that in Massachusetts and in Rhode Island that will protect injured employees. Unfortunately, it's a lengthy process, and that's why I think most people, are afraid of, reporting these injuries. But, my experience is that people that typically do not report the injury usually end up having a harder time anyway. And if, in fact, the employer knows through the grapevine that there is an injury, if there's a layoff or some type of termination, or they artificially create some type of reason to get rid of an employee, that person's going to lose their job. And it further, without getting into too much detail, further complicates the case as far as them getting weekly compensation benefits, because the defense will raise what they call a loss of earning capacity argument, stating that they were employed continuously up until a layoff. So it creates a lot of legal problems by, just simply, if you would just simply report the injury and be forthright with it, it makes things a lot cleaner and simpler.